4 topics: disciplinary and grievance hearings, performance management, adjustments in trickier cases, and COVID vaccinations. If you've any questions during our presentation this afternoon, please email victoria@cursandgreen.co.uk. We'll discuss these, any questions that come through in a Q&A session at the end, so just feel free to email them as and when. And I'll now pass over to Jessica for part 1.
Thank you, Lauren, for the introduction. So I'm going to take a look at conducting disciplinary and grievance hearings in a work from home world. So the first question really, what's changed and what stayed the same? So it certainly feels like everything has changed this past year, and a lot of employment law obviously has. However, there are still consistencies. So despite lockdown, COVID and furlough, employment law and their existing rights still apply in their pre-2020 format. One of those rights that still exists is to raise a grievance. You as the employer are still able to discipline someone, and conduct is a fair reason for dismissal. Lauren will be looking at another one of those reasons, capability, shortly. One of the other rights that still exists is that employees with qualifying service of 2 years still have a right not to be unfairly dismissed. So if you do discipline someone, then the process is going to be key. Process is also going to be key for grievances. This inevitably leads to some frustration because we're trying to fit a square peg of existing employment law and guidance into the round COVID hole. In terms of looking at discipline and grievance, then the best place to start is the ACOS Code of practice on discipline and grievance procedures. So if you aren't familiar with that as an employer, it's definitely worth taking a look. That sets out what the current best practice is, and it's what the Employment Tribunal will look to. So I've mentioned ACOS. If you're not aware of who they are, they're the Advisory, Conciliatory and Arbitration Service. So they're an independent public body. They provide free and impartial advice to both employers and employees, and they can help you out when things go wrong. So they have numerous amounts of free guidance, they have templates, and they have training available. So the next thing to look at is your own internal policies and procedures. So review these and see whether they're fit for purpose. And if they're not, then you're going to want to review and update them alongside the ACOS code. If you do update them, obviously make sure you tell your employees once that's been done. ACOS have also produced a handy guidance note on discipline and grievance procedures during the coronavirus pandemic. So we expect that when cases do start to trickle through the tribunal are going to give this credence. And the final thing that you need to comply with is public health guidelines. So considering the slightly tricky matter of furloughed employees, so employees who have been designated as furlough workers are still employees and still retain their existing employment rights. They're still going to continue to accrue length of service, so that's important to keep in mind, as once they get to 2 years service they get additional rights. So that includes to a statutory redundancy payment and the right to claim ordinary unfair dismissal. Whilst on furlough they can still raise a grievance, so that might be to do with things that have occurred before furlough or during furlough. So for example, if they have a grievance about how they were selected for furlough, you're still under a duty to investigate that as an employer, and it's important not to prejudge the outcome. For furloughed employees, you need to follow the government guidance on the coronavirus job retention scheme. So part of that eligibility for you to make a claim for somebody's wages is that they can't do any work for your organisation or do anything that will provide services for your organisation or any linked or associated organisation. So it's been confirmed that where a furloughed person is the person that's raising the grievance or is having a disciplinary against them, then that falls outside of providing services or making money for the organisation. ACOS guidance have confirmed that those people can take part in discipline and grievance matters as long as it's in line with public health guidance. The potential issue that we're seeing is where managers or witnesses are those people that are on furlough, so potentially that's them performing services for the company, so they probably can't conduct the hearing and you still be eligible to make a claim for their wages. To eliminate that risk, we would probably suggest that the investigator, the meeting chairperson or the note taker is probably put onto flexi furlough to avoid them being seen as doing work. So in that case, you'd be able to then pay them for the time that they spent doing that on their usual wages in the usual way, and then keep them on flexi furlough for the remainder. Witnesses, again, the question is, who are they providing services for? ACOS guidance previously suggested that they could be involved if this was voluntarily, but that's not in the current form of the guidance. So to avoid falling foul of legislation, as we say, it might be better to either postpone until everyone's back off furlough, see if there's another way to get any evidence that those witnesses might be having. So, for example, CCTV, if you've got contemporaneous emails, or, as we say, temporarily place them on flexi furlough with their agreement. So looking at the guidance, so the ACOS Code says that discipline and grievance matters should be conducted in a manner that's fair and reasonable and without unreasonable delay. So the question really is can you do that at the moment? What would be unreasonable delay? So a lot of workplaces are obviously closed, so many industries are closed in their entirety, so it may not be possible to conduct a hearing at all. If your workplace is currently open and people are attending, then potentially that's a bit easier to deal with. You just need to follow the current guidance on working safely during the pandemic, and that includes conducting a risk assessment. If you recognise a union, then we would suggest that you consult with them about your approach. And really, it just needs to be a balancing act between the need to undertake these discipline and grievance processes and following the specific public health guidance. So in deciding whether to proceed with discipline and grievance matters now, there's lots of things that you should consider. And what you should do will really need to be a case-by-case consideration. So we would suggest that you have conversations with the employee involved, the employee's companion or union rep, and the other people that are going to be involved. So obviously you'll have an investigator, you'll have a decision maker, and potentially you'll have witnesses as well. ACOS suggests within its pandemic guidance note that the things to consider when making an informed decision are whether any of those people listed have a good reason to suspend the process or to go ahead with it. Does anyone that will be involved have any concerns about holding the meeting either in person or remotely? And are there any concerns about how the employee can be fairly accompanied, because they still have the right to be accompanied to the hearing? One of the things to think about is the seriousness or the urgency of the matter. So does the investigation need to happen now? Have a think about minor disciplinary issues compared to, for example, a complaint about sexual harassment. Issues can and will still arise while you're working remotely. Just because someone's not physically in an office, for example, doesn't mean that things might happen. Is the delay going to make an ongoing situation worse? So think about the impact of the delay on the well-being of the individuals involved. It can be very stressful for employees to go through discipline and grievance matters at the best of times, and it's only going to be worse given the current lockdown. Think about tribunal claim limits, so time limits. So, for example, discrimination claims generally have a limit of 3 months less a day, with some extra time for early conciliation. So if you dealt with a grievance that had elements of discrimination sooner rather than later, that might avoid a tribunal claim being put in. Think about who's involved, so who's going to conduct the hearing, and as I said before, if the decision maker's on furlough, that might be a consideration in whether to proceed now or to postpone. Think about the right to be accompanied, so the individual still has a right to be accompanied and to have a companion. To think about how you're going to accommodate that. Make sure you keep a record of any decision that you've made, so you can show that you've thought about all these things. These are going to be your friend, particularly if there is a subsequent tribunal claim. So keep a note of why you decided to proceed in a particular way. As a practical point, we'd suggest that perhaps you treat it the same way as you would if you were dealing with a discipline or grievance matter with an employee who was on sick leave. So would you proceed in their absence, or would you delay matters? So if you do decide to go ahead remotely and carry out the procedure remotely, it's worth having a think about how you're going to do that. So we would usually suggest video is preferable. You can see people's body language, which is going to be particularly important if you've got conflicting accounts of events and you're being asked to determine who's more believable. Check that everyone has access to the system and do a test run first. So bear in mind that there might be accessibility requirements for specific employees, which we'll look at later. Make sure you use a secure platform to ensure that confidentiality is maintained. So make sure that's password protected and remind everyone who's attending of their duty of confidentiality. You could also ask the employee to confirm that no one else is present in the room with them, for example, except for the companion that's allowed. Think about the documents you're going to be providing to people. So how are you going to do that? Is it going to be electronic? Again, make sure that everyone has access, and we suggest that you circulate any documents or any evidence in advance. It might be that you decide to then use screen sharing to go through it together in the hearing. If the physical workplace is closed, then have a think about how you're going to gather any evidence that you need, and how is the employee going to be able to gather that evidence. Thinking about that might be a factor in whether to proceed or not. If you can't access documents or evidence, you might not be able to proceed at this current time. Thinking about taking statements from witnesses. So how are you going to gather those? Are you going to set up telephone calls or video calls with those people? The employee, as I say, is still entitled to have a companion. So think about how they'll be able to confer privately with the employee. So you could use breakout rooms, or you could agree that they'll just drop off the call and call the employee. There's a potential increased risk of an employee covertly recording one of these hearings. So have a look at your discipline and grievance policy and see what it says about recording meetings. Covert recordings are admissible in employment tribunal proceedings. One possible option is to just take control and record the meeting yourself and then share it afterwards. You can use that again as evidence in a tribunal hearing, and might be a good supplement to notes which you should be taking anyway. If you are going to record the meeting, then make sure you tell the employee that you're doing that, and make sure you update your privacy policy to deal with it. And finally, employees are still going to have the right to appeal any decision. So when you're dealing with an appeal, you're going to need to go through these same considerations. In terms of the risks, so the risks of getting it wrong, employees with 2 years service have unfair dismissal rights. Awards for compensation can be increased by up to 25% for failure to follow the ACOS Code on discipline and grievance matters. You might risk a claim for constructive dismissal or breach of contract if you've got contractual discipline and grievance policies. However, we would always suggest that discipline and grievance policies are non-contractual. And there's also a risk of claims under the Equality Act 2010 for failure to make reasonable adjustments, for example, but we will look at that later on. So I'm going to pass over now to Lauren to look at the nuances of performance-related matters.
Thanks, Jessica. Okay, so we're going to look at performance now. Obviously, with all that's going on, there's a question about how do you begin to evaluate your employees' performance in this challenging time? How much should you consider the impact of COVID on performance, if at all? How do you make sure you're fair-minded, given everyone's different circumstances? So the starting point is that fairness remains the foundation for effective performance management. We need to start with the basics. So working backwards, poor performance can lead to a dismissal, and there are 5 potentially fair reasons for dismissal under the Employment Rights Act, one of which is capability. So whether a capability dismissal for poor performance in the end is fair will depend on the reasonableness of the employer's decision. So did the employer honestly believe on reasonable grounds that the employee was incapable of performing their job? Did they follow a fair process? And an important element of this will be considering whether the employer has clearly communicated the requirements of the role and has provided support and training to the employee. With COVID and working remotely, how much support and training has been given, that will be scrutinised, and the evidence to prove this will become relevant should complaints arise. Looking at a fair performance process, the following basics should probably occur. A proper investigation into performance issues needs to take place, and the employee needs to be made aware of the problem, of course, and given an opportunity to respond and improve within a realistic timescale. So what period of time is considered realistic? It's fact sensitive. It'll depend on the circumstances of the role. If your capability procedure, for instance, if you have one, sets out some sort of timescales, you need to adhere to that. Equally, if there's an industry standard, that might be reasonable to follow. Often it'll make sense to link the timescales to a natural part of the business cycle. For example, quarterly sales targets or the duration of a particular phase of a project. The employee needs to be given support and possibly training that's fact sensitive as well. For example, there's a tribunal case where an employer brings in a whole new IT system, employee is not trained on it properly and is dismissed for poor performance in not using the system well. That was of course held to be unfair because the employer didn't do what it should, didn't provide support and training. And couldn't rely on the poor performance as a fair reason to dismiss that person. Employees' progress needs to be regularly reviewed during the period, so the reviewer must play their part too. Targets must be realistic and achievable. If they're not, there's invariably going to be arguments from the employee that they've been set up to fail, that the outcome is predetermined. So we'd suggest that any performance targets are agreed with the employee and that this is recorded in paper, have them sign it, have them tick to say, yes, I accept these. It's also going to be important for the employer to diarise the review period and stick to those meetings. It's going to be unreasonable if the employer adheres to its side of the process. So we've dealt with the case where an employee was put in a performance improvement plan and then the employer failed to arrange or attend any actual meetings, failed to do any of this during lockdown, didn't send any updates on progress. The employee needs to be offered a right of appeal against any ultimate sanction at the end, and certainly against a decision to dismiss. And obviously that appeal process needs to be fair too, and in accordance with any policy that you have. And then finally, document everything. So have employees sign papers to accept things as fair, achievable, keep minutes, ensure everything's in writing, your targets, and this is all going to be important evidence, and it should be on the personnel file anyway. To avoid formal performance issues rising, employers should manage performance issues on a day-to-day basis, and this does apply in the remote world too. So you can firstly do this by making sure you've set the required standards. So it's implied into every employment contract that an employee will perform to a minimum standard, and it might actually be set out contractually as to what this actually covers. Usually it covers technical aspects of the role alongside more subjective aspects such as how the employee gets on with colleagues, their attitude. Those in very senior roles are expected to adhere to higher standards and should know what is required of them, and should know when they do not meet minimum standards. Importantly, though, the standards need to be communicated. So although some of it's implied and some of it's too obvious to be drawn attention to, for instance, a van driver should probably not need to be told that he should not drink alcohol before driving the van. If there are specific performance targets, performance markers, then these should be communicated clearly to the employee, draw their attention to it. Again, advise them, sign, return, email, have records this has been done. Secondly, the use of probationary periods are a really effective tool and an ideal time to assess performance of an employee. Usually the employer's risk is limited in this period. There's usually a 1-week notice period during probation, and the employee will not have achieved 2 years complete service, which is necessary for an unfair dismissal claim. Appraisals, these are always very important, particularly in lockdown. Some employers during the pandemic have let these slide, but they are critical to protect the employer in the future. In order to be effective, appraisals should be conducted honestly, and managers who provide unduly positive or flattering feedback, which does not reflect the employee's actual performance, may find that this is later used against them to undermine a disciplinary decision in the end. This is unfair, you never raised this before in my appraisals. Employers who fail to tackle performance issues properly and head on through an appraisal system may find it hampers their decisions, business decisions in the future too. So for example, if you're running a redundancy process and performance is one of your criteria to mark against, if you're going to rely on a low performance score, the previous appraisals need to corroborate that. So be honest, transparent, record issues. And the practical reality of confronting an employee it can prove daunting for some. They may prefer to let matters drift. Others may simply want to avoid the time-consuming process of a performance management procedure. However, taking early action, A, it could avoid the need for that formal process later. B, it will demonstrate support in the team, which can be good for morale. And C, it helps maintain positive performance when there is good morale. Providing informal feedback generally and always being there to improve individual performance will help avoid serious issues developing. There will be cases where performance issues do need to be treated formally. The ACOS Code, which Jessica mentioned, reiterates the important principle that employers should firstly carry out a thorough investigation, provide the employee with the findings of that, and allow the employee an opportunity to respond. As a result, the employer might find that there is no formal action to be taken, or they might find that a formal performance process needs to be launched. The employee should be notified of this and a meeting held, and this should be done in writing. An email will suffice. The ACOS Code requires those types of meetings to be held without unreasonable delay. And Jessica touched and will touch on the practicalities of these meetings in the remote world. But it should broadly be held not so quickly so that the employee hasn't had a time to properly prepare their case. Adhere to any timescales set out in your performance improvement plan or your disciplinary policies. As a rule of thumb, a meeting notice of less than 2 working days or perhaps more than 10 working days is probably going to be unreasonable. And we do need to consider time for setting up remote meetings and making sure that everyone's comfortable with those. The aim of the formal meeting is going to be to set out the performance issue, give the employee an opportunity to respond, examine the cause of any underperformance. Is there more at play here that we need to know? Determine what remedial action could be taken, if any, and obtain the employee's commitment to reaching those standards that are discussed and agreed. So again, having agreement from the employee that the standard is achievable is going to help. And then a reasonable time scale to improve needs to be set. Monitoring system needs to be agreed between you. How will it be done remotely? An employee needs to be told what will happen if they don't meet the standard. Is it going to be a warning? Is there a risk of dismissal? Note that the ACOS guidance distinguishes a disciplinary warning, which tends to relate to misconduct by referring to performance warnings as improvement notes. So you might want to use this type of language as it feels more supportive and positive in a performance sphere. While there's no obligation on an employer to consider alternatives to dismissal if it should reach that stage in a performance case, employers should do it, as it might be unreasonable not to consider if there's anything else and record those decisions. A question that often arises in performance management cases is it possible to dismiss instantly for one act of incompetence? And in our view, it would be very rare for one act of poor performance to be so grave to justify a summary dismissal. So what difference does remote working make to all of this? The basic principles can and should continue to be applied, notwithstanding the fact that people are working remotely. Continue to monitor, and you can do so in the various ways now: Skype, Teams meetings, reviewing work. You still need to do that even remotely. However, I mean, employers should take into account the fact that employees have been working in unfamiliar territory. It may have an understandable impact on performance. So at this stage, employees might well have been working remotely for a year. So things might be settling, but it is very much still an unknown situation, and employees need to be sympathetic to the stresses that could cause. It's reasonable to acknowledge this in any performance process. Have you adjusted your performance requirements to account for this? And if you have, you need to share this and communicate it with employees. Consider how long any adjusted performance plans are going to run on for, considering the government's plan to come out of lockdown. Regular conference calls, team calls should be set up. Periodic review of work, so think of shared folders and make sure that you are tracking that and saving it so everyone's got records. Actually, email and tracking on documents and providing comments in this way is actually really good at the minute because we've got a lot of records electronically. Be clear on how work is going to be submitted to the person who's monitoring it, and feedback continue to be given. Meetings, Jessica will touch on this again, but obviously they don't have to be in person anymore, but still have them. Sometimes it's good to see face to face via these types of tools like Zoom that we're on. But remember that some employees have difficulty in accessing or setting this up at home, so make sure that you run tests and do trials. During the meeting, a performance meeting, I wouldn't suggest sharing for the first time the evidence. It's better to email that in advance, do a small PDF bundle, for example. You don't want your employees having allegations of being ambushed or feeling unprepared or not have just been shown something on the screen quickly. Don't forget to take your minutes of note of these meetings, put them on the personnel file and share them in the same way that you would have done in the office. And in summary, the fundamentals of your performance process should be the same and fair as if you were working in the office. If it's not, you might face an unfair dismissal claim or unfair process. And in fact, in my view, employees are more likely to scrutinise and have employers under the microscope in the remote world with everything recorded, so employers should handle with care. Just finally, whether in the remote world or not, there are claims if performance issues are not handled correctly. So follow your performance policy. If it's contractual, you could open yourself up to a breach of contract claim. Have all policies and procedures to hand and make sure at the outset you know what you're meant to do. Communicate any adjustments to these policies clearly or to account for any remote working. Employees might argue that any ultimate dismissal for performance for a capability reason is unfair on the basis that the allegations are unsubstantiated. They were never given any warning that performance was an issue. So again, your past appraisals are really important and paper trail. They were not given a reasonable timescale to improve. Having them agree about the timescales is going to be important here. Targets are not realistic, same point applies. There's also discrimination risks. So disparity of treatment, for instance, dismissing one employee for a particular type of underperformance and not the other. Let's say it's one sex over the other. You could face that could be well perceived as being sexist. If poor performance is dealt with in a heavy-handed or oppressive manner, you could lead to a harassment allegation. Let's say you've got an unwell employee suffering mental health issues at home. A heavy-handed process in that case is not wise or fair. It's going to open you up to legal risks. And Jessica will actually speak further on these more tricky and sensitive cases.
Thanks, Lauren. So I'm going to look at some specific cases and potential issues that might arise. So under the Equality Act, there's 9 protected characteristics, and individuals that hold those have a right not to be discriminated against because of them. Of those, I'm going to look at disability, sex, and age. It's worth keeping in mind that people with greater caring responsibilities might also be at a disadvantage at the moment. So consider things like associative discrimination. Obviously, schools have reopened, so that's helped slightly, but people are still going to have issues with childcare and might need to consider flexible working more closely than you would usually. So first, turning to disabled employees. So consider whether your employee has a disability that might impact on the procedure that you're going to carry out, so discipline, grievance or performance management, and whether any reasonable adjustments are required to that procedure. It's worth thinking about the fact that if somebody is clinically extremely vulnerable and is required to shield at the moment, then they are likely to be considered disabled within the meaning of the Equality Act 2010. So you need to make sure you don't discriminate against them. That could extend to witnesses as well in these sorts of situations. So don't force someone to come in to participate in this process or have contact with other people if they can't, if they're required to shield. So have a think about any reasonable adjustments that you can make to make the process less difficult for any employees that have these disabilities. So to remove any potential barriers compared to an individual that didn't have that protected characteristic of disability. So think about it when you're setting up the hearing. So for example, a deaf employee that uses sign language or lip reading is going to obviously require a video call. Think about any auxiliary aids that you can introduce to your meetings that might help. So Enhance the UK have some really useful tips on that. For example, deaf employees, you could utilise subtitles in your meetings. That might also be good for employees with distractions around the house. So anyone that's got children around at the moment or pets, for example, you can set up the subtitle feature for them. Other things that can help if you're having a video call, you can get headphones that fit over hearing aids, you can get neck loops which are compatible with hearing aids and implants. You could provide your employee with larger monitors, joysticks instead of a mouse if needed. Other things that you can do to make it easier is to send an agenda in advance so that everyone can follow it. You can limit the length of any hearings or investigation meetings to avoid Zoom fatigue, so make sure everyone takes regular breaks. Patience is going to be crucial, particularly with those with communication impairments. Have a think about the impact of body language, for example, on those that have autism. Think about, for example, people that have social anxiety disorders. They might actually struggle with a Zoom call compared to a telephone call. The right to be accompanied, so usually that is only extended to a union representative or a colleague, but it might be that you consider that as a reasonable adjustment, you allow the individual employee to have a family member to accompany them. So that way they might feel more comfortable having someone who's physically present rather than via a screen. Lots of these things would actually be quite good just to adopt anyway, just to make things easier for people. And if there's any doubt at all in your mind about what you should be doing and whether this person can take part in a hearing, we always recommend that you get an occupational health report. So sex discrimination. So lockdown and COVID have had a disproportionate effect in the workplace on women with children. So during lockdown, women were more likely to work in sectors that had to completely shut down. So, for example, hospitality, 23% of women compared to 16% of men in those industries. The study for the Institute of Physical Studies has found that mothers are 23% more likely than fathers to have lost their jobs during the current crisis. Further, this study also showed that mothers are far more likely to be interrupted during paid working hours than fathers. So almost half of mothers' hours spent doing paid work are split between that and other activities such as childcare, compared with under a third of fathers' paid working hours. So even where women could continue to work, they were less likely to do so or were less able to dedicate the same amount of time due to childcare responsibilities. So have a think, as an employer, should you discipline or performance manage for this as a reasonable employer? We would say that you risk an indirect sex discrimination claim if you do on that basis. We'd suggest that you discuss alternatives with the employee. So it's confirmed in the government guidance that furlough can be used for childcare. If you do decide to take quite a heavy-handed approach and discipline or performance manage for this, then obviously you've got some risks there. You're risking negative press. You might find it difficult to attract and retain female employees. From a practical perspective, we suggest that you train your staff on how to deal with flexible working requests. You could also go on the forefront and offer greater flexibility yourself, so ask people what's going to make their lives easier. If somebody's dealing with a grievance or disciplinary or performance related matter, have a think about whether the employee has somewhere private to go and take part in that meeting. If employees are working flexibly, how are you going to accommodate everyone's schedule and everyone's timing? We'd suggest that you make sure you just adjust timings in the working day to suit everyone that's going to be involved. So, for example, don't schedule a hearing at the same time as the school run. The last thing that I'm going to look at is age. So, is to avoid potential discrimination claims on the grounds of age. So make sure you ask everyone if they can use the technology that you're providing. Don't just assume. Make sure you provide the training to everyone equally, and then offer additional support to anyone that needs it. So make sure you don't generalise. So don't sort of say, oh, well, Pete won't be able to attend this Zoom hearing because he's 65. Make sure you train people, ask them if they can use the technology and accommodate any additional support that you need. The key takeaways is to make sure that the process is fair and make sure it's reasonable, and that applies to discipline, grievance and performance management. For example, you might need to allow the employee to rearrange a hearing, so best practice is for them to be able to rearrange it once, but you might have to do that more than once in the current situation. If it's not possible to have a fair and reasonable hearing, then you may need to suspend the process. And now I'm just going to pass over to Lauren to give our views on the controversial no job policy.
Thanks, Jessica. So obviously the vaccination rollout is continuing, so we're going to look at some question and answers on this evolving situation and no jab, no job as it's been dubbed. Can employers require staff to be vaccinated against COVID-19? Vaccination is not mandatory in law, and Matt Hancock has said that the government is not considering making it mandatory. Employers therefore don't have a statutory right to require employees to have the vaccine. According to ACOS, employers should be supporting staff in having the vaccine and not forcing staff to be vaccinated. ACOS also flags the important point to remember is that vaccination is not the full answer, and workplaces do need to continue to be COVID secure and adhere to the government's guidance on that. However, you've probably heard about in the news, one of the UK's largest care home providers, Care UK, is making vaccination a requirement, and all employees need to have a COVID-19 vaccination before starting work, and they're joining a similar approach taken by Pimlico Commerce, who did call it no jab, no job. It raises a myriad of legal risks, human rights, discrimination, controversy generally, and a mandatory requirement could result in negative publicity, could have a detrimental impact on your business's profitability, employee retention, and recruitment. Can employers make it contractual? So can this form part of your contractual requirements? It would amount to a change to an employee's terms and conditions. Agreement is needed by any employee to change the terms and conditions, and employees may well not agree. An employer in that situation is faced with either forcing the change on the employee or dismissing the employee for not accepting it and perhaps offering to re-employ them on the new terms. There are very high risks attached to this process, and it's likely to result in an unfair dismissal claim, particularly for those employees with over 2 years service. Risk might be lower with new staff, so if you introduce a new contractual requirement and roll it out to all new staff joining, because it's not a change, it's something they'd be accepting from the outset. But this won't deal with the entire workforce, and it also raises a number of risks. It could still be discriminatory, particularly if exceptions are not covered. For example, a blanket contractual requirement to have the vaccine could impact certain groups more than others. For instance, those with a disability or health condition who have been advised that the vaccine may not be suitable for. You could end up with an indirect discrimination claim. So changing employees' contracts to include a strict vaccine requirement is risky in our view. Employers must remember that the vaccine is not suitable for everyone, and we think, and it's the right advice currently from ACOS, to communicate, consult and introduce a voluntary policy which focuses on encouragement. So can employers discipline or dismiss staff if they refuse to be vaccinated? It will depend on whether the employer has decided to bring in a contractual policy or not, and the risks that brings, or whether there's a workplace policy. Previously, the government said that employers should consider whether vaccination is necessary for the employee to do their job, meaning, for example, in high-risk care sector due to vulnerable care home residents. Notably, that's been removed from government guidance earlier this year. So no doubt that's been removed due to the legal risks of including that type of thought process. It's arguable that the requirement is alternatively a reasonable management instruction because employers need to provide a safe place of work. There's a legal requirement, a duty of care. So therefore, if an employee fails to follow a reasonable management instruction and refuses a vaccine unreasonably, that could result arguably in disciplinary action. To this end, the government has said that vaccination is recommended for those working in care homes or caring for the elderly or vulnerable, frontline social care workers or healthcare workers, and those aged 65 and over or in the clinically extremely vulnerable group. However, there needs to be a very careful weighing up of the concerns of the particular employee, their particular circumstances, the government guidance and recommendations, and the business needs and why it's going down that route. For example, let's say the refusal is because the employee has a mental health illness that is triggered by vaccination. You are exposing yourself potentially to a discrimination claim and to an unfair dismissal claim if you've dismissed the employee for not being vaccinated. There's guidance out there that certain people with particular allergies or immune disorders will not respond well to the vaccination, so this needs to be accounted for. If you do get an unfair dismissal claim, for example, in your hands, it attracts up to 52 weeks pay. Potential discrimination issues, yes, there are many. Our advice is generally tread carefully. So an employee might be, as I alluded to, might be unable to get the vaccine because of a health condition such as allergy, immune disorder, mental health issue, phobia of needles. This will give rise to allegations of disability discrimination if it's not accounted for or reasonable adjustments put in place. Potential age discrimination. Vaccine rollout is largely based on age at the minute, with older individuals being offered the vaccine first. This means that younger members of staff may be unvaccinated for a longer period of time. They may be ineligible to be vaccinated until later this year. So any differences in treatment between vaccinated and unvaccinated staff could amount to arguments that it's ageist. Certain religious or moral beliefs could be protected in law. For example, an anti-vaccination stance could arguably amount to a philosophical belief protected in law. There's also arguments about the use of animal produce and animal welfare in vaccination. Currently, no case law on this. It's too early, but I do anticipate there will be arguments in the months to come. Pregnant women, so they've been advised not to have the vaccine. A prudent employer should also consider that women choose not to tell their employer about pregnancy until a particular time, and they need to be sensitive to this, and the fact that women trying to conceive may not be willing to take the vaccination and may refuse it, and these could lead to pregnancy discrimination or sex discrimination arguments. So it's clearly a sensitive matter which needs careful consideration and careful handling. A blanket rule will not work. Individual scenarios need to be considered and accounted for, and we say it needs to be covered best in a well-drafted policy. That's going to be your key. Discrimination claims have no financial cap, so unfair dismissal awards 52 weeks pay, discrimination claims uncapped. So it could any unfair or discriminatory treatment could come with large cost consequences. So are there alternatives to forcing or making it mandatory? Yes. And we say employers should be considering how best to achieve voluntary vaccination as opposed to mandatory vaccination. have a good, well-drafted policy, inform staff about the advantages and disadvantages of vaccination, provide information, links, government website advice, listen to employees' concerns, and focus on encouragement. So to encourage, employees might consider paid time off to attend the vaccination appointment, paying full pay rather than SSP if employees are sick with side effects from the vaccination, not pointing any vaccination-related absence towards any absence records, and consider any temporary changes to work. So could the employee be put in another part of the business where they don't need to be face-to-face with others? Can they continue working from home if that's been working effectively? What about regular rapid COVID testing in the workplace? Even if these alternatives don't work, employers should make sure they do give meaningful consideration to them, record it, so that if complaints are brought in the future, they have evidence that thought was given to it. It's obviously an evolving situation, so we also need to keep updated with what the government is saying and with case law. And finally, data protection risks. Are there any with vaccinations? Yes, there are. So details about an employee's vaccination status is special category health data. So employers need a particular legal exemption to have it and to process it under data protection laws. You should have a data protection policy. It might not cover this explicitly because when the Data Protection Act came in recently, we didn't have COVID, so we might want to revisit that and update our policies to ensure it does cover this. And potential grounds for having and processing this data is that it's necessary for employment obligations, such as providing and maintaining a safe place of work. How will your information be kept safe? Who's going to have access to it? It's sensitive information. Policy needs to cover this, the collection of the data and how long it's going to be retained. So even if it's going to be permitted by data protection laws and it's covered nicely in your policy, an employer cannot compel an employee to disclose such information against their will. However, we do think it's reasonable for employers to ask generally, as part of general encouragement of vaccination, to ask for evidence as part of a wider policy of encouraging everyone to be vaccinated, the theme being support, and getting voluntary sign-ups rather than having to force employees.
Thank you, Lauren. So just a few final points before we move on to a Q&A section. So I can see that we've had a few come in, but please feel free to email Victoria, or if you pop her a message in the chat box, she'll make sure they come over to us with any questions. So the contents of today's presentation is up to date as far as possible. However, it is only a summary. With COVID-19, the law and guidance is ever changing. So always make sure you check the up-to-date position. And if you have any doubts, please take specific legal advice. A lot of the legislation in this sphere is as yet untested. So we don't have relevant case law on dismissals during COVID, for example. We don't expect to see the decisions and judgments until later this year at the earliest. The current caseload of the tribunals is very backlogged, particularly in the southern regions of England. So we're having cases from 2020 listed for as late as 2021 and 2022. So the repercussions of any of these decisions is going to be seen for in some time. So question. So we've had a question. So what happens if the employee's home environment is causing a negative impact on performance and is worried about attending the office, even if you follow public health guidelines? Lauren, I suppose that fits into what you've been saying quite nicely. My first thought would be to make sure, as part of the investigation, to establish why it's having a negative impact. So what particular features of the home environment are causing that, and if it's connected to a potential protected characteristic, so disability, for example, or sex. So if you've got childcare responsibilities, you're going to want to establish that right at the start to make sure that you're not, you're not heading into a discrimination claim. Laura,
yeah,
yeah.
I think the discrimination element is what sort of flagged to me, and you should probably be considering alternatives to, if someone's feeling uncomfortable about attending, finding out why, and then working out what you can do as a business reasonably to support it. You can obviously show them risk assessments that you've done, the protection that the business has put in place to make sure coming into work is safe. But then there's considerations maybe around taking public transport, which you need to account for. We are advising in a similar type of case, and the employee suffers from a particular disorder or disease, which would mean that they're potentially disabled. And so the practical solutions is actually that the employee can do certain tasks at home still. There are certain elements of the job that need to be done in the office, but the employee is just going to be furloughed because the scheme's obviously been extended now. So the employee will be part furloughed to resolve that. And hopefully by the time the scheme ends, we'll have everyone vaccinated, which should alleviate sort of some of the concerns.
Yeah, absolutely. And the guidance is work from home if you can. It leaves it to the employer really as to whether employees can work from home. Ultimately, if you have an employee who is refusing to come in and you've investigated that and there's no legitimate reason, then potentially you can look at disciplinary matters. An employee can refuse to attend their workplace if they think that their health and safety is an immediate danger. And it's worth considering what that means to different people. If an employee is clinically extremely vulnerable, then they're going to see that immediate danger is much worse than somebody that isn't. And there is a risk of a claim there, which you don't need the 2-year service requirement for. If it would be an automatic unfair dismissal. So that's definitely worth bearing in mind. But if you've been through the process, if you've carried out a proper investigation, you've complied with all your public health requirements, and the employee's just refusing to come in because perhaps it's not convenient, then you can certainly look at disciplinary matters and potential dismissal. If somebody is refusing to come in, it may well be gross misconduct, but we expect you'd probably be better to go down the sort of warning route and give them the opportunity to come in, particularly as everything is changing quite quickly at the moment.
Yeah. We've had a question in respect of holiday. And in respect to the quarantine period, so the government has put a quarantine period for people returning from certain areas for 10 days, and it's what will employees get paid during that period, and that's a good question. This is all uncharted territory, and at the minute there's a couple of options. So if an employee has come back and has unplanned, it's changed whilst they're away and they come back, then perhaps you could consider the employee being able to work from home if they've been able to do that, and pay therefore wouldn't be any different. If it's a case that the employee's booked to go to a particular place knowing that they're going to come back and have to quarantine, then you need to consider in advance, and perhaps having a good policy on this and clearly communicating this would help. Those considerations: is it going to be unpaid leave? Are they able to work from home as normal, or should they use it as holiday and use up the holiday entitlement that they have, 10 days of their holiday? An employer can give notice to an employee to take holiday. It just needs to be double the amount of time. So if it's 10 days quarantine, you need to give 20 days, broadly 2 weeks, you need to give 4 weeks notice that they must take that as holiday. That will depend on timings. But I think thought needs to be given to this, particularly coming up to the summer period where people are hoping to have some sort of travel plans this summer, and a policy to cover what does happen. It should be communicated.
Yeah, absolutely. And it's worth just pointing out that if your employee is self-isolating, then it's an offence for you to knowingly allow them to attend work, and you might be issued with a fixed penalty notice. I think that's probably all we've actually got time for, because we've got to 1:30 now. So thank you everyone for joining us. If you do have any other questions or any feedback, then please feel free to contact Lauren and I by email or on LinkedIn. But otherwise, as I say, thank you for joining us.
Thank you.
Bye.
Bye.